Okay, Chair, we're live on YouTube.
Thank you. I'd like to warmly welcome you to this virtual planning control committee that is being conducted with members and officers at various locations, communicating via audio, video and online. And there's also the opportunity for the public and press to listen and view the proceedings live on our YouTube channel. Before the meeting starts, I would like to invite the committee member and scrutiny officer to explain how proceedings will work and to confirm that members, officers and our registered speakers are in attendance tonight. So I'd like to hand over to you. Yes. Yeah.
Thank you, Chair. So I'll go through a roll call just to confirm everyone's here and they can be heard and be seen. So Councillor Brown.
Here.
Councillor Allen.
Here.
Councillor Bryant.
Here.
Councillor Derbyshire.
Yeah.
Councillor Hewson.
Yeah.
Councillor Hunter.
Present.
Councillor Levitt.
Yeah.
Councillor Moody.
Here.
Councillor Nguala.
Here.
Councillor Prendergast.
Here.
And Councillor Rice has just joined us. If you could just confirm you can hear it. Thank you, Councillor Rice. And Councillor Tyson.
Yes, I'm here.
Thank you. And the officers, Simon Ellis.
Here.
Thank you. Richard Tiffin. Richard Tiffin, want to unmute yourself?
Present.
Thank you. And Nuanetta Katavu.
Here.
Thank you. And public speakers, Councillor Carol Stanya.
Here.
Thank you. David Farrell.
I'm here.
Lynn Bogey.
Here.
Michael Cadler.
Good evening.
Thank you. And Philip Holland.
Here. Thank you.
Thank you very much. So I'll run through the proceedings for this evening. The meeting is being streamed live on the Council's YouTube channel and Zoom. If live streaming fails, the meeting will adjourn. If the live stream cannot be restored within a reasonable period, then the remaining business will be considered at a time and date fixed by the Chair. If the Chair does not fix a date, the remaining business will be considered at the next ordinary meeting. If for any reason the meeting is not quorate, an officer will notify attendees by interjecting the meeting, and the meeting will adjourn immediately. Once the meeting is quorate, the meeting will resume. If connection cannot be restored within a reasonable period, then the remaining business will be considered at a time and date fixed by the Chair. If the Chair does not fix a date, the remaining business will be considered at the next ordinary meeting. If a remote member loses connection, the Chair may adjourn the meeting for a short period to enable connection to be re-established. If the Chair does not adjourn the meeting, the member will be deemed to have left the meeting at the point of failure and be deemed to have returned at the point of re-establishment. Only members present for the entirety of debate and consideration of an item are entitled to vote. If technology fails for a member of the public who intends to participate and is unable to do so, the Chair may decide to adjourn or proceed to the next item of business to allow for connection to be re-established. If connection cannot be restored within a reasonable period, the Chair can decide to conclude the remaining business. If a member or member of the public drops out of the meeting and is unable to connect by video, an email has been sent to each of you with telephone options. And as always, please ensure your electronic devices are muted and that you've activated your mute button on the tablet or your computer when you're not speaking, and also deactivate your camera when you're not speaking. And the rules of debate remain the same. If you wish to speak, please use the raise hand button, and then the host will inform the Chair of the names of the speakers who wish to address the committee. When satisfied there has been sufficient debate, the Chair will request that the relevant planning officer reads out the recommendation that members will be voting upon. And when requested to vote, voting will be via the green tick for yes, red cross for no, blue hand for abstain, which are all located in the participants section at the bottom of the screen. And please do not vote until it has been confirmed that all raised hands have been cleared. Details of how members voted will not be kept or minuted unless, of course, a recorded vote is requested or an individual requests that their vote be recorded. And it will not be heard or seen on the audio and YouTube recordings of the meeting. And the committee member and scrutiny officer, which is me this evening, will clearly state the result of the vote, and the chair will then proceed to the next agenda item. In the event of a tied vote, the chair will have the casting vote. Are there any questions before we start the meeting? Okay, I can see none. So if I hand back to Councillor Brown to take over, thank you.
Thank you, Matthew. So our first item tonight is apologies for absence. I don't believe we have any, is that correct?
Correct, Chair.
Okay. And notification of any other business, I have none. So let's move on to number 3, Chair's announcements. So audio recording. In accordance with Planning Control Committee policy, this meeting is being audio recorded as well as filmed. The audio recordings will be available to view on ModGov and the film recording via the NHDC YouTube channel. Declarations of interest. Members are reminded to make declarations of interest before an item. The detailed reminder about this and speaking rights is set out under Chair's announcements on the agenda. So I'm going to spare you by not reading all of that out. So it's there for you. To clarify matters for the registered speakers, members of the public have 5 minutes for each group of speakers, i.e. 5 minutes for objectors and 5 minutes for supporters. This 5-minute limit also applies to member advocates. A bell will sound at 4.5 minutes to alert you that you have 30 seconds left. And at 5 minutes, a bell will sound again to signify that the speaker should stop speaking. Lastly, I just want to say that I am going to have a break after items 5 and 6, or at 9 o'clock, whichever comes soonest. And that will be a 5-minute comfort break. We don't have any public participation except those speakers that have been registered under the various items tonight. So we'll move on to item 5. Land west of Tuthill House, Kelshall Tops, Thurfield, Hertfordshire. Outline application for erection of 6 dwellings, all matters except access reserved. So I'd like to invite our planning officer, Richard Tiffin, to introduce the item. You need to unmute.
Yes, I've worked that one out. Good evening, everybody. I won't be using video. It's far easier to do it without video, so for me anyway. So you'll have to forgive the lack of a visual presence. There's some updating on the first item, corrections. They're minor corrections to the report. At 4.3.9 in your report, can you delete then section 52? At 4.3.43, the penultimate sentence should read on the private car, not of the private car. Condition 2, the first sentence should read on private transport. I had a problem with ons and offs, I think. So it should read on private transport, not off. And condition 4, delete final plan. There's too many plans. That's all the corrections. Do you want me to take you through the slides now, or do we? I can't remember how we did it last time.
Yes, please.
Yeah. Can we have the presentation up, please? Thank you. Next slide. Next slide. This is the site. It'll become clearer when we look at the photographs. But this is the site, former or current yard on the west side of the village of Thurfield. Next slide, please. This is a photograph taken from Pedlar's Lane, looking towards the junction with the Kelshaw Road. It's taken because this is one of the routes from the site to the school, and members will note, members who don't know the area will note the lack of a footpath. Next slide. And this is a view in the other direction, looking towards the village up Pedlar's Lane. And I didn't take it because there was a sign showing the parent and child, but it's useful. It usually demonstrates there's no footpath again to the school. Next slide, please. This is a view from the site entrance looking towards the village of Thurfield. Again, I'll draw your attention to the absence of any footway. Next slide. And this is a view along the Kelshaw Road from the entrance to the site towards Kelshaw. And again, you'll see that it is a narrow country lane, passable at best by an extreme amount of caution by 2 vehicles. Next slide. This is a view of the yard as it is, or as it was 10 days ago. Next slide. And that's the entrance, the current entrance to the site. Next slide. This is a view from the Kelshaw direction approaching the village. You'll see the sign on the left. You can just make it out, the Thurfield Village sign. The site is where the public footpath sign is, that the land beyond that over the vegetation is the site. Next slide. That's just another one of the same, but you can now see the Thurfield Village sign very clearly. Next slide. This is a view from Mill Lane. The road directly that runs from right to left or left to right is the causeway. That runs to the left. You're going into the village of Thurfield. To the right, you're going towards Royston. The road opposite Mill Lane, where the photograph's taken, is the Kelshaw Road. This picture was taken to demonstrate the absence of a footway as well, particularly on the junction between the Kelshaw Road and the causeway. Next slide. This is a plan showing the proposed 6-unit scheme. The entrance, the access you can see there is the access from, as taken from the photograph showing the gated entrance. And you can see the village to the right and the Kelshaw Road running right to left towards Kelshaw. Next slide. This is a street scene. So looking at the top is a view of the site as it exists today. It's not a terribly accurate representation, but it gives you some idea. The next section down is a site as it would appear developed from the Kelshaw Road, and the bottom section is as it would appear from the land to the rear of the site. That's open countryside. Next slide. These are just some indicative, the application is outlining form, but these are indicative elevations of the dwellings that might go on the site. So next slide. Next slide. And that's just a red line around the site. And next slide. That concludes the presentation and the corrections to the report. Thank you, Chair.
Thank you. So now I'd like to invite the first of our registered speakers, Lynn Bogey, to speak to this item. You have 5 minutes. Would you like to unmute yourself and put your video on?
Okay.
Welcome.
Okay. Can you hear me?
Yes.
Okay, thank you. Well, my name is Lynn Bogey and I'm the owner of Tathill Manor, a two listed building adjacent to this development site. Others, including the Thurfield Parish Council and my neighbours at Tathill Farmhouse, with whom I have shared my speaking note, have confirmed their support for what I have to say. I and they object in the principle of residential development on this site. We wholeheartedly agree with the officer's recommendation that both applications be refused. This is poorly designed, inappropriate development of land in a rural position outside the development in the midst of Thurfield, a site which did not meet the criteria for inclusion as a development site in the emerging local plan. The site is unsuitable in terms of highway and access and fails to promote sustainability for reasons identified in the officer's report. Please also note that whilst it's claimed that Tathill Manor is accessed through Tathill Court, it cannot be. The sole access, which it shares with Thurfield Water Tower, those visiting Thurfield allotments and the farmers who access their fields this way, is via the lane immediately adjacent to it. An access for the proposed development immediately next to the existing junction would be highly dangerous, especially as there's every reason to expect that the highway within the visibility display will be used for parking. People parking in our lane to avoid dangerous on-road parking would prevent not only day-to-day access, but necessary maintenance and repair and access by the emergency services, both to my property and the water tower. The applicant also claims that the location of the proposed access will allow the appropriate visibility displays to be achieved on the site. The applicant's plans, however, show that the visibility display is in part over land not owned or controlled by the site owner. It's pointless to approve an access which relies on the cooperation to our detriment of landowners who oppose the proposed development. In reality, this application is based on a false prospectus, and the nature and extent of the misleading information both taints the consultation and demonstrates such a disregard for the true position that no reasonable authority could rely on it to grant permission. I've got limited time and the reasons are many. I've also got some very new information which wasn't available in the consultation. I'm going to concentrate therefore on three key assertions by the applicant. These are, and I quote, that planning permission was granted in 1992 to use the site for the open storage of agricultural machinery and as an operating depot for 4 heavy goods vehicles. This use is ongoing, they say, and generates a significant amount of vehicle movements each day. Secondly, that the site is previously developed land, what used to be called brownfield site, and attracts favourable treatment when considering development. And thirdly, that there's no Section 106 agreement relating to this site, or it's out of date and no impediment to the granting of planning permission or the proposed development. All three assertions are made in the applicant's supporting documents and repeated or not withdrawn in the new addendum. Councillor Morris, my councillor, also heard the site owner made these assertions at the Thurfield Parish Council meeting in May, but all three assertions are incorrect. The reality, as you saw from the photographs, is that the only significant use of the site and the only significant traffic movements arise out of the unlawful breakers and scrapyard currently on the site and referred to in the officer's report. This activity has occupied substantially the entire site with the agreement and to the profit of the current site owner. The site is not an HGV depot. The Section 106 agreement provides that only HGVs owned by the site owner can be parked on the site, and the site owner doesn't own any HGVs. Nor is it, as is clear as a matter of public record, does he have or ever has had a vehicle operating licence, a legal agreement required to operate in an HGV depot. It is in fact clear that there's been no such licence in relation to this site for over 20 years. There's no significant lawful storage activity on or coming and going of vehicles to the site is also manifest from the site owner's recent post on the village chatter, which reads, however, it now appears that this, the current planning application, is not an application supported by the parish council. And if it fails, I will have no choice but to leave the site as it is and hope that the travelling community doesn't decide to take it over. The addendum, following comments received in the consultation, concedes that planning compliant operations are in fact small scale, but claims they could be scaled up. It suggests that the site owner, at odds with the current statements I just read, intends to, quote, make a commercial decision to optimise the use of the site should these proposals be unsuccessful. Whatever the site owner's actual intentions, I can say that I've owned my property for over 25 years. The site owner has not operated the site as an HGV depot or agricultural storage business, and the prospect of his doing so now seems slight. So does the spectre of a new site owner operating at an intensive level, and it would have to be a new owner to comply with the Section 106 agreement. To be clear, however, I would be fine with, I would be fine with any activity on the site which complies with the planning permission and the terms of the 106 agreement, and prefer such activity to residential development. This is not a brownfield site. There's been recent information relating to this, which I would be very happy to explain if I had time, and you may ask me to do that. I will move on, though, to the Section 106 agreement, giving the limitations on time. An application was made to discharge that agreement less than 2 years ago, which was withdrawn
5 minutes,
after the officer
Chairman.
indicated it had to be refused.
You have had your
I'm sorry,
time. I'm sorry, I will have to
Okay.
stop you there. Okay, I'd like to invite,
Madam Chairman,
yes,
Madam Chairman,
yes.
I'm sorry, I have very little left to say, but given that I've had to deal with a post-consultation document which was published on the website either late last month or early this, can I just finish? I have less than half a page to read.
I'm sorry, no, you will have an opportunity
right.
to answer questions though, so you might be able
Okay,
to
thank
put
you.
those points across that way. So I'd like now to invite
Possible.
members to ask any questions. Do any members have questions of our speaker? Oh, Councillor Nguala.
Hello, thank you for your presentation, Lynn. I just wondered, could you finish what you were reading? That's my question.
I certainly will. There's not much more. Given the limitation on time, I'll move on to the Section 106 agreement. An application was made to discharge the Section 106 agreement less than 2 years ago, which was withdrawn after the officer indicated it would be refused. The application had to be refused as a matter of law, since it cannot be discharged if it serves a useful purpose, any useful purpose. It doesn't need to be the original purpose or indeed a planning purpose. This agreement continues to serve many useful purposes and is currently being used by the Council to bring an end to the unlawful breakers' activities at the site. Varying or releasing a Section 106 agreement is a separate process from consideration of a planning application. And in the hopefully unlikely event of the committee being minded to grant one of these applications, the appropriate procedure, respecting the legal rights of the owners of Tat Hill Manor and Tat Hill Farmhouse, who are identifiable beneficiaries of the agreement, would need to be gone through. The committee cannot properly decide today to amend or discharge that agreement. The applicant will claim it has support. However, the village has been desperate to get rid of the unlawful breakers' yard run from the site during this application process, and has been influenced, as must have been intended, by the site owner's published statement regarding the travelling community. The serious misrepresentation of the legal and factual position has also played its part, as is apparent from many of the representations which refer to those 3 tenets.
I think that's probably long enough now. Thank you.
Okay.
Are there any further questions? Okay, there are no further questions, so I'd like to thank you. Thank you for your presentation, and invite you to turn off your camera and mute yourself now. Thank you.
Thank you very much.
I'd like to now invite our second speaker, Michael Calder, to address the committee. You have 5 minutes.
Good evening. Thank you. I'm Michael Calder from Phase 2 Planning, speaking on behalf of the applicant. This proposal seeks outline planning permission for 6 new homes with detailed design reserved for future consideration. Officers agree that this application is to be determined in accordance with the planning balance as set out in the National Planning Policy Framework. The difference between the applicant and your officers is whether the tilted balance applies and the weighting of harms and benefits in the planning balance. There are 3 strands of sustainability as set out within your officer's report: social, economic and environmental. In respect of the social strand, in light of a substantial shortfall in the Council's 5-year land supply, currently 1.3 years, an adopted local plan whose housing policies expired in 2001, and delaying the adoption of the emerging local plan, the delivery of much needed family housing should be considered a significant benefit. In addition, the NPPF supports the provision of housing in rural areas such as Thurfield, because housing can contribute towards the enhancement and vitality of existing local services within the village, and development in one village can support services in a village nearby, and this is supported in paragraph 78 of the NPPF. For these reasons, it's our view that housing benefits from the delivery of much needed housing on this site should be given significant weight in the planning balance, tilted or otherwise, which is greater than the moderate weight given by your officers. On the economic strand, there's no disagreement between the applicant and your officers that the delivery of housing will bring with it economic benefits, which include job creation through construction, local labour and supply chains, but also increased workforce created by new residents and increased local housing spending in local services. We agree with officers that this should be afforded moderate weight in favour of the proposals. On the environmental strand, we wish to highlight that this proposal seeks outline planning permission with detailed design reserved for future consideration. Whilst the applicant supported the proposal with illustrative designs, the final design is still very much a matter to be decided and presented in the future. There is therefore flexibility within this outline application to address matters of design through the final details of layout, landscaping, scale and appearance. In close and long distance views, the site's well contained within the existing landscape boundaries to be retained and enhanced with further planting. This isn't accurately represented in the current illustrative plans. The change in the character of the site from a commercial storage yard to residential will have limited impact on the character of the area, with the surrounding rural agricultural land outside of the site most strongly contributing to the local character and setting of the heritage assets. For this reason, and those put forward by the applicant's heritage expert, the applicant does not believe that the heritage presents a clear reason for refusal, and consequently, the weighted tilted balance should apply in this proposal. This proposal provides 4 parking spaces per unit, with double garages and 2 spaces in front, and inclusion of vista spaces. This provision can be increased through future reserve matters. The level of parking will not therefore result in pressure for parking within Kershaw Road. There is access to the centre of the village and its facilities from the site via public rights of way network. However, it's also a fact that a significant number of local roads leading to the centre of the village do not have footpaths along them, and therefore it's very common for residents to walk around the village in a public highway, and drivers' behaviour will be aware of this and adjusted accordingly. The NPPF is realistic that cars will still be required for some journeys, but because the overall benefits to development in rural areas, the objectives of securing sustainable development is a far wider concept than not using a car, and it justifies a more balanced approach. One important matter missing in the officer's report is acknowledgement of the site's previously developed land status. NPPF paragraph 118 advises that using suitable brownfield land should be given substantial weight. Overall, and in accordance with the balanced approach, we consider that there's limited to moderate harm, environmental harm, which does not significantly and demonstrably outweigh the positive effects of the weighted tilted balance and the clear social and economic benefits of the development. We know that there are outstanding matters raised by the local lead flood authority and the Environment Agency. These are capable of being addressed by a condition. In response to what you just heard from the neighbouring resident there, your officer's report adequately addresses the matters concerning the Section 106 agreement. Therefore, tonight,
Chair.
in your support for this proposal. Thank you very much.
Thank you so much. I'd like to now invite members to ask any questions. Do we have any questions for our speaker? Oh, doesn't look like it. So thank you very much, Michael.
Thank you.
You may leave us now or listen in. Okay, I'd like to now invite our planning officer, Richard Tiffin, to respond to any of the points that have been raised by the speakers.
Hello, Chairman, can you hear me? Hello, Chair, can you hear me?
I can hear you, yes, thank you.
Okay. No, the only point I would there were lots of issues raised there, but I think they're all adequately dealt with in the report. So I won't go into any of those issues. The only point I would raise, and clearly Mr. Calder's view, and he's perfectly entitled to take it, is that the tilted balance, the presumption in favour of sustainable development applies in this case. It's my professional opinion that it doesn't, and that's a legitimate point of disagreement. In my view, the other point I would pick up was his observation that the report does not address whether the site is previously developed land. I have the NPPF open in front of me, and there's a definition on page 70 of previously developed land, and with the committee's forbearance, I will just read that to you. Land which is or was occupied by a permanent structure, including the curtilage of the developed land, brackets, although it should not be assumed that the whole of the curtilage should be developed, brackets, and any associated fixed surface infrastructure. This excludes land that is or was last occupied by agricultural or forestry buildings. The assertion that the land is a commercial storage yard is not true in my view. It's not a commercial storage yard. It may have been used for storage, but that was in contravention of the 106 agreement that's in place. So my view is this is not previously developed land, and therefore that the concessions available for developing PDL can't be applied. Thank you, Chair.
Okay, thank you for that clarification. Do members have any other clarification questions for our officer? Councillor Nguala.
I just wanted to ask, thank you. I just wanted to ask about 3.4, the local lead flood authority objection, that the report submitted by Ardent Consulting Engineers did not comply with the requirements and therefore couldn't be used. Could you just talk us through that and explain, should we not go back and ask for a proper report?
Through you, Chair.
Yes.
Given the recommendation, I didn't think that was necessary. If members were minded to approve the scheme against recommendation, then that's something that we would clearly have to do first. But given the local lead flood authority have taken a view based on inadequate information, that has to be a reason for refusal. But as Mr. Calder says, that if members were minded to take a different view to that set out in the recommendation, that could be a condition, but that's not my recommendation.
Okay, thank you.
Councillor Bryant, do you have a question for our officer? Oh, no? Councillor Bryant, do you have your hand up?
Yes, I have.
You
Yes,
have
I've got a
question for the officer. Okay,
yes.
Thank you.
My question concerns 4.3 heritage issues. My starting point being that Fairfield Heath is very significant in the archaeological knowledge of this area. It is a unique landscape with the Motte Bailey Castle, which is Tut Hill, is very, very close to this development. It's 70 metres or something like that, plus the surrounding area, which has got Norman and Anglo-Saxon remains. And I was looking at what Heritage England has said, and what I would like you to explain is why in 4.3.434, why you've decided that less than substantial harm is tilted in that way that you have decided. Because from my knowledge of Historic England, they are a bit mealy-mouthed about these things, and the less than substantial harm means there will be harm. And I think we need to take that on board. And I just wondered what your reply to that was.
So, Richard, can I ask you to respond to that?
Yes, through you, Chair. Well, I agree with everything you've said. There is less than substantial harm is harm nevertheless. But it isn't the paragraph 196 sets out the rules of engagement for less than substantial harm. And yes, I agree. And that's why in the planning balance, the less than substantial harm carries the weight it does. It doesn't mean that the term less than substantial harm is perhaps a little confusing, but it's a term used in the National Planning Policy Framework. It means a level of harm which is not significant in the sense that paragraph, let me just get the paragraph for you. Paragraph 196 of the framework says, where a development proposal would lead to less than substantial harm to the significance of designated asset. 197, the effect of an application on the significance or of a non-designated asset. Let me just find it. Yes, I can't. Oh, well, 195, where a proposed development would lead to substantial harm. So we've got two levels of harm set out in the framework. I agree with Historic England that the level of harm appropriate here is less than substantial rather than the higher, which is substantial. Of course, that's a matter of judgment, professional judgment. Members are entitled to take their view, but my view is the same as Historic England's pretty much, that it's less than substantial harm. I don't know if that helps, Councillor.
Thank you. In some ways it does. I do think we need to take into account the feelings of the local people and the significance that Fairfield has got in historical terms. And remember that when we are talking in the legalese of the planning framework. Thank you.
Thank you. So we have Councillor Hunter. Would you like, you've got a question for the officer?
Thank you, Chairman. I think actually 4334 actually sums up where Mr. Tiffin is coming from as far as Heritage England are concerned. But I don't really feel that it's close enough to Thurfield Heath for the two to have any link whatsoever. But that's neither here nor there. And I'll leave my next comments for the debate, Chairman.
Okay, thank you, Councillor Hunter. Okay, so if there are no further questions, and I can't see any further hands, let's move to the debate. Councillor Levitt.
Thank you, Chairman. I've tried to look at this from both sides of the planning regulations, the NPPF, and look at it in purely planning terms. Whilst it is true that we do not have a 5-year land supply and the emerging local plan has been held up for some time, although I believe it's due to move forward again in September now. That aside, there is so much against this application, against this site, that I completely agree with the officer's recommendation on this. It's not in the emerging local plan. From memory, it was promoted when we did the call for sites and it failed on a number of reasons due to sustainability, etc. So that's why it wasn't in the emerging local plan. We have 3 objections from statutory authorities: the Flood Authority, the Environment Agency and CPRE have all raised objections. We have the problems of the sustainability of the site. It's outside the settlement boundary of the village. It fails to meet paragraphs 127 and 57 of the NPPF. It fails to meet paragraph D1 of the emerging local plan. And on top of all that, despite it being a site in the open countryside with nothing around it, it fails to meet the minimum parking standards at new developments with just 6 houses on it. Totally agree with the officer's recommendation to refuse the application. I would happily move that recommendation, Chairman.
Thank you. I've got, before we go for a second or anything, I've got Councillor Allen would like to speak.
I just wanted to say that I agree. There are so many different reasons to say no. I'm very happy to say no, and I'm very happy to second Councillor Levitt.
Thank you. So before we move to a vote, I've got a few more people who want to speak. Councillor Hunter, did you still want to speak? Or did you not take your hand down?
Thank you, Chairman. Yes, I do want to speak. In fact, Councillor Levitt's covered a number of the issues that I was going to bring up. But I'd just like to say to Mr. Tiffin that this is an excellent report. And in fact, one I think ought to be used as far as training is concerned. The analysis of policy against the NPPF and the for and against is excellent. And it covers all levels of planning. And I did enjoy the verb I haven't seen since school days, which is on 4314 opine, which I haven't seen for a very long while. So I'll commend him for his excellent use of English. And actually, I'm not able to propose or second the recommendation, but go with it 100%, Chairman.
Thank you. Is there anyone else who would like to speak before we move to a vote? No, let's move to a vote. So can I invite our officer to lead us through the vote?
Thank you, Chair. So as you use the green tick to support the recommendation or the red cross to go against the recommendation.
So just to be clear, if you put the green, we're refusing the application, and red
That's
is
correct.
Support. Okay.
Yeah, green to support the recommendation and green to go against the recommendation.
No, sorry, you just confused everyone. Green
Sorry.
to refuse as per the officer's recommendation.
Yes, sorry, Chair. Okay, Chair, that's carried to refuse.
Thank you very much. Okay, I think we can move on then to item 6. So item 6 is the same piece of land west of Tuthill House, Kelshall Tops, Thurfield, Hertfordshire, but this time it's an outline application for erection of 18 dwellings with appearance and scale reserved. I'd like to invite our officer to update us and to present the report.
Thank you, Chair. Can you hear me?
Yes, I can.
Okay, good. Can we have well, there's some corrections. Let's do the corrections first. The 4.3.7 in your report, this for the avoidance of doubt, this is 118 OP. We've dealt with 117 OP. Delete then section 52. The reason for that deletion is that section 52 agreements were a part of the 1971 Act, not the 1990 Act. 4.3.45, the penultimate sentence should read on the private car, not of, again. And 4.41, the citation of 4.3.34 in that paragraph should read 4.3.37. Condition 3, reason for refusal 3, sorry, not condition 3. First sentence should read on private transport, not of. And reason for refusal 5, delete the final plan. There's an extra plan crept in there, and I don't know why. So they're the corrections to the report. Turning now to the slide presentation, can I have the second slide, please? Again, same slide, so I'll move very quickly through this. And these are the same views. So if you just keep cycling through those photographs, members have already seen these until we get to the plan. If you could stop there. This is the scheme for 18 units with a centrally located access point, and the 18 units in a courtyard style around a central space. Next slide. That's just a red line around the side. This was outlined. Oh yes, okay, they're out of order, but never mind. So this again is the top section is a view from the Kelshall Road as exists today. The second section down is as proposed, and the third sections down are the site. I can't actually read those, but I'm fairly certain they are from the looking at the site in two parts from the field, from the land beyond the development site. Next slide. And some indicative elevations provided. Next slide. Next slide. And the final slide, I think that's it. So that concludes corrections and presentation through you, Chair.
Thank you. Are there any questions about this application for the officer? No. Okay. I'd like to invite Lynn Bogey to come and to speak. Are you still there, Lynn?
I am. I can't start video because the host has stopped it. My computer tells me.
Okay, so would you like to speak to us without video then? So you have 5 minutes. A bell, well, you will get a warning at 4.5, and I will stop you at 5.
Thank you very much. I can be much briefer on this because many of the points which I raised in relation to agenda item 5 apply equally to this agenda. As then, I've shared my speaking note with the Thurfield Parish Council and the owners of Tuthill Court, which is the other property principally affected by the proposed development, and they've both confirmed their support for what I have to say. Again, we wholeheartedly agree with the officer's recommendation that this application be refused. This is a poorly designed, inappropriate development of land in a rural position outside the development limits of Thurfield on a site which didn't meet the criteria for inclusion as a development site in the emerging local plan. It's inappropriate to the sensitive nature of the site and would materially adversely affect my listed property and the Thurfield Conservation Area. This development is urban in character, overcrowded, and wholly unsuited to a very visible site in the countryside. The site is also highly unsuitable in terms of highway and access and fails to promote sustainability for all the reasons identified in the officer's report. There's likely to be serious traffic from such a major development, and I'm concerned about the road safety implications of a new major junction so close to my access lane. I repeat the concerns expressed in relation to the previous agenda item regarding parking on that lane, and the lane to my house and the water tower. I also repeat the comments I made regarding the misleading nature of the application, particularly as regards PDL, and the fact that the nature and extent of the misleading information both taints the consultation and demonstrates such a disregard for the true position that no reasonable authority could properly rely on it to grant permission. Thank you very much for hearing me in relation to both this item and the previous item.
Thank you. Do we have any questions for our speaker? No, if not, then I would like to invite Michael Calder to speak in support of the application. You have 5 minutes and I will warn you at 4.5.
Thank you. Many of my previous comments that have just been made in relation to this first proposal, we would only make here again. So I don't propose to repeat all of those from what you've just heard. I'd therefore instead like to just perhaps pick up and address some of the points we've heard this evening to see if that might help. So we recognise that this site wasn't carried forward through the local plan for allocation, but it doesn't end there. The NPPF is quite clear in the case that we face in this district at the moment, with an absence of a 5-year land supply and an out-of-date local plan, the applications are to be considered on their merits. You've heard from us that we feel that the applicant's case is that significant weight should be given to the social and economic benefits of the earlier proposal. Well, this proposal for 18 homes would have significantly greater benefit in terms of delivery of housing. An explanation as to why this is for 18 homes. Well, the idea behind this was it gave a more balanced mix of housing to meet needs that were perceived to be in the village in terms of more smaller properties. You probably would have picked up from your officer's report that there are some residents that are actually in support of this proposal, and that was certainly the soundings that the landowner took at the time of conceiving this proposal. And the officer's report notes a couple of supporting comments from locals for a greater mix of and a significantly more number of units than was in the previous proposal for 6. So therefore, this application sought to address that and give some choice to locals. You've heard some previous comments there in relation to previously developed land. So I just wanted to make the applicant's position on that clear. You may have had the opportunity to review the addendum report dated June this year. And just to clarify the applicant's position that's set out within that report, a building was erected on this site in the 1970s, as set out in paragraph 2.21 of that report, through a planning permission granted in 1972 for the erection of a storage building. So if we go to the definition that was explained to you earlier by Mr. Tiffin, that definition would apply because it refers to land that was occupied by a building, by a permanent structure. This site did have that building, the footings are still there, and the hard standing is very much for all to see. So we say that this site does meet the definition of previously developed land, and again, reference to my earlier comments that should be given substantial weight in this decision. Reference to less than substantial harm to the heritage asset, it comes down again to a balance of public benefits and whether the judgment is made to whether those benefits outweigh that harm. Contrary to your officer's opinion, the applicant and the heritage expert that informed the applicant's application takes the position that the social and economic benefits that I discussed earlier outweigh the less than substantial harm, which is considered to be on the low level. I think, therefore, all I would really conclude by saying is that the applicant's position, as noted earlier, is that in accordance with the balanced approach that the NPPF advocates, the environmental harm that's set out in your officer's report, we say, doesn't significantly and demonstrably outweigh the positive social benefits of delivering 18 much needed family homes. And we say that accordingly, the balance would support the grant of planning permission in this case. And I think I'll leave it there. Thank you very much.
Thank you very much. Do members have any questions for our speaker? Councillor Levitt.
Good evening, Mr. Calder. We're picking up on the substantial harm issue. Could you just tell me what the density per hectare is, dwellings per hectare is on this development, and how that compares to the current dwellings per hectare within the surrounding area in the village?
Certainly. If you bear with me one moment, apologies. So I've got my mic on. So, I have that written in front of me. You'll excuse me, it's not on the top of my mind as much as it should be. I do apologise. I mean, without giving you the number, which I will do in a moment, I can acknowledge that the density of this development is greater than the density of its surrounding neighbours. There is no shying away from that fact. What we say is that the site-specific circumstances of the site's well-contained boundaries, landscape boundaries, contains the site from its appreciation outside of its immediate context. So where we approach this from a point of view, 31 dwellings per hectare, sorry. So undoubtedly the development around the site will be less than 31 dwellings per hectare. I couldn't tell you exactly what it is right now, but what we say is that the landscape containment of the site and the fact that it isn't appreciated widely beyond its boundaries is that density would not have a harmful impact.
The density around it's just over 12 actually. And this is without outside the village boundary, but yes, 31 as opposed to 12. Thank you.
Acknowledged.
Okay, thank you. Are there any further questions for our speaker? No. In which case I'm going to invite our officer to respond to any issues that have been raised. Do you have anything to say, Richard?
Through you, Chair. Just a couple of points. The first point is the argument based on a tilted balance. You can only engage a tilted balance, i.e. the presumption in favour of sustainable development, if you take the view that the harm to the heritage asset doesn't present a clear reason for refusal. Manifestly, the recommendation is that it does, so the tilted balance is not engaged. So this is a neutral test. Does the public benefit outweigh the harm? So that was the first point. So again, I have to agree. Mr. Calder is perfectly entitled to take the view that he thinks the tilted balance is engaged. As an officer, I take the contrary view, and the reasons for taking that contrary view are set out clearly, I believe, in the report. The second point was on the previously developed land issue. The building, if there was a building there in 1972, I believe, was cited. The definition of previously development land excludes land that is or was last occupied by an agricultural building. If that building was indeed in 1972 an agricultural building, and with no way, well, there may be a way of determining whether it was or not, then it wouldn't have qualified as previously developed land anyway. But I think that's something of a red herring. I think that in the planning balance, you have to assess all harm and all benefit overall. And I think it was Mrs. Bogey that said she characterised this as an urban scheme. I would agree with her. And I think the difference between the 6-unit scheme and the 18-unit scheme is you could possibly or charitably attribute the word suburban to the 6-unit scheme, which in itself is harmful, in my opinion, in a village location. 18 units is manifestly urban. And I think that point's demonstrated by the question that Councillor Levitt put to Mr. Calder around density. I mean, it's 31 dwellings per hectare. That's similar to the Fairview scheme north of Royston.
Okay, thank you very much. Can I invite us to move to the debate then? Would anybody like to speak? So I've got Councillor Allen.
I think that after having reviewed this, the overdevelopment of the area speaks for itself. Much the same reasons as previously put forward. I think it is correct to refuse this as per our recommendation. So I would like to suggest that we refuse.
So are you moving the recommendation?
I am moving the recommendation.
Thank you very much. So Councillor Hunter, I have you next.
Thank you, Chairman. I was going to do similar. I think this is 3 times more unsuitable than the previous application. As to the previously developed land, because the footings are still there for a building for storage, doesn't hold any weight, or the drum that we keep being beaten with at the moment is the 5-year land supply. But in this particular instance, I'm quite happy to second and go along with the officer's recommendation, which I think is excellent.
Okay, thank you very much. So we have a proposer and a seconder. Would anybody else like to speak before we go to the vote? No. So can we go to the vote? Matthew, can you lead us through the vote then? Thank you.
Yes, thank you. So just to make sure it's clear, so using the green tick to support the recommendation and the no red cross to go against the recommendation. Okay, that's carried, Chair, to refuse.
Thank you. So as I said at the start, we're going to take a short break now. By my clock, it's 20:27. So I'm going to say if we come back at 20:35, that gives us just over 5 minutes. And we will move on to item 7. So thank you very much. See you in then. Welcome back. Do we need to take another roll call?
If you like to, Chair, we can do another roll call.
Or can you just check from the list of participants who's here? Or do you want to do a roll call? Is it necessary to do a roll call?
I don't believe so, as we no one disconnected, did they? So should be able to go on. I can see everybody's here, I think.
Can you just have a quick check and see if you think there's anyone missing? I'd rather not have to do a roll call if we can avoid it.
Yeah, everyone's here, I can see on the screen.
In which case, let's start. So we're moving on to agenda item 7, which is for land between 24 and 26 Cedar Crescent and 92 Greendrift, Royston, Hertfordshire, for the erection of 1 detached 2-bed chalet-style dwelling and associated works. And for this item, I'm going to invite Simon Ellis, our Development and Conservation Manager, to present the item and give us any updates. Thank you, Simon.
Thank you, Chair, and good evening, members. What I was going to do is just go through the slides, and then I'll try and slowly go through the planning history, because it's quite complicated as to why we've ended up where we've ended up on this site. So if I can have the slides, please. Can I have the next one, please? So this is the site location plan. You've got Greendrift to the north, and then vehicular access off Greendrift and pedestrian access off Cedar Crescent to the south of the site, and you can see those 2 strips of land. Site shown with 1 house and a garden, and you can see the house to the right, the second of the pair granted permission in 2014, referred to in the report, the other being the dwelling on the application site. And there's a displayed layout of the 2 dwellings with existing shed access off Greendrift. Can I have the next slide, please? So this is a photograph of the side elevation of the existing house on the site, number 92 Greendrift. That's showing you where there's need to be a few changes just to allow the access to the development. Can I have the next slide, please? So this is the pedestrian access to the rear of the site from Cedar Crescent, that narrow strip there going into the back of the site with the bungalows on either side. Can I have the next slide, please? This is a photograph from within the garden of the application site, showing the position of the proposed dwelling beyond the footpath on the rougher strip of lawn just beyond there. Can I have the next photograph, please? This is a wider view of the same spot. The site of the proposed dwelling would be beyond the footpath seen in the photograph, and you can see the bungalows on Cedar Crescent beyond. Next slide, please. Slightly further back, this is a view of the site towards 24 and 26 Cedar Crescent again. And next one, please. Turning around, this shows the location of the proposed extension to the access, to gain vehicular access to the proposed new house. So that where that gate is effectively where the access would come in to serve the new dwelling proposed. Can I have the next one, please? This is the narrow vehicular access of Green Drift, which currently serves the two houses I was referring to, granted permission in 2014, and will be extended to serve the proposed house in this case. Can I have the next slide, please? This is a wider view of the same access with the bungalows on either side of Green Drift. So you can see how narrow the access is with the hedgerows on either side. Can I have the next slide, please? This is the first plan. This is the red line plan. And the next one, please. This is the block plan. So you can now see the pedestrian access coming to Cedar Crescent, to the back of the proposed new dwelling. And then you can see where those gates I was showing you on the earlier photograph, where you'd then have 2 car parking spaces just beyond that to serve the new development. And that's the access off Green Drift. So that's the block plan that shows you the eventual layout of the development if you were minded to grant planning permission, and the space between the new house and the 92 and 90 Green Drift, and then 26 Cedar Crescent and 24 Cedar Crescent. You can see where this one would sit right in the middle of that cluster of homes. Can I have the next slide, please? This is the elevations of the proposed dwelling. Quite modern looking. Can I have the next slide, please? And here's the floor plans, rooms in the roof space, ground floor plan, first floor plan, showing you how you could circulate from within the house. And the next slide, please. That's a slightly more close-up version of, oh, hang on a minute, that's the existing house on site. Can I have the next slide, please? And that's showing you the existing house, notes number 92. And next one. That's it for the slides. Okay, no need to look more slides. I'm going to go through the planning history very carefully now, just to get you to a position to understand why we are where we are. So first of all, planning permission was granted in 2014, and that's shown on paragraph 1.1 for 2 dwellings with access off Green Drift, including the demolition of the existing house. This scheme was built, and number 92 is one of these 2 dwellings which share the existing access of Green Drift. That's the first part of the planning history. Second part is that before that scheme was built, a planning application for 3 dwellings was submitted, and that's shown in 1.2 in 2015. And this was refused planning permission for 4 reasons. So they got permission for 2, they didn't build it. There was then an application for 3 that was refused planning permission. 4 reasons for refusal. And then there was an appeal against that decision, and that was dismissed. And the main concern of the inspector was the effect of traffic movements from 3 dwellings on the living conditions of the bungalows on either side of the access. So the inspector already knew there was a permission for 2 dwellings, but he thought that 3 was too many and that you'd get too much traffic and you'd get noise disturbance going down that narrow vehicular access. So the next part of the planning history is shown at 1.6. Permission granted in 2018 for a swimming pool building in the same location of the proposed dwelling here, and this was granted. The building would have been very similar scale and form to the proposed bungalow. So arguably, in terms of spatial impact, very similar to the spatial presence of the proposed dwelling here, just a different use, and a swimming pool building connection with number 92. So that sort of sets the framework for a building on this plot, but albeit not a new dwelling. So then 1.7 shows permission refused for a single dwelling on the site for the same reason that the inspector dismissed the earlier appeal. You can follow what I'm saying now. For the 3 dwellings, and that was refused on the grounds of the noise impact from the traffic. Going down the access route for the 3rd house in the cluster. The current proposal is for the same development as that refused in 2019, with an accompanying noise assessment to demonstrate low-level noise effects of additional traffic on the facade of the bungalows on either side of the access. And this noise assessment, as is set out in the report, has been assessed by the council's environmental health officers and found to be sound, and they raised no objection to the proposal. Their comments are set out in paragraph 1.3. You'll see there in the environmental health officer's recommendation, they support the idea of an acoustic fence on the access, but then you'll see the officer's review and the applicant's view, and support that is that if you put an acoustic fence down there, you're going to interfere with a hedgerow, you're going to affect the character of the area, and the noise report does say that the acoustic fence, whilst being beneficial, wouldn't actually, without the acoustic fence, the noise effect is still below the sort of nationally recognised standards. And also, I think you've got to bear in mind there's already 2 houses that serve that access, so an additional 1 bungalow. What's the actual additional traffic here? And if there's a noise assessment that says it's not going to be that severe, then in terms of evidence, the officer's recommendation is that refusal reason is overcome, because we don't have a noise objection to the proposal. So that's it. Our view is that there's sufficient evidence to overcome the refusal of the 2019 application. Also, the report sets out the rationale that over this sequence of events, the range of issues is narrowed down to what we effectively left with is the noise issue. And appreciate if you look at it from the beginning to end, it sounds like they tried to get 2 houses. They got permission for 2 houses, then they tried to get 3. That was refused. Then they tried a swimming pool. That was granted. And now they thought, well, let's try a house. That was refused. And here we are again. So it's sort of been narrowed down over the years, but it is material to take into account earlier decisions of the council. There, significant material considerations. And I think that swimming pool permission is a bit of a giveaway, because that gives you the block that the house is proposed, and then you've got the noise report. So I wouldn't say you're boxed in, but it's going to be difficult to come up with a different conclusion other than to grant planning permission. But that's it for my updates. I'll take any questions. Thank you, Chair.
Thank you, Simon. Can I invite members who'd like to, okay, I've already got Councillor Levitt, you've got a question for our officer?
Yes, please. Good evening, Simon. You said one of the previous applications had been appealed. Was this refusal for the single dwelling in 2019 appealed as well?
Through you, Chair, no, it wasn't appealed. The 2019 was, the reason why we've got this current application is because the applicants now submitted the noise assessment to demonstrate that the reason for refusal of the 2019 application in the noise assessment has been overcome. So once you examine the noise issue, they're wanting you to grant planning permission, and they're saying, look, here's our noise report. We've got an acoustician to demonstrate that reason for refusal isn't right, and that has the support of the environmental health officers.
Okay.
So no, the appeal was the 2015.
Yeah.
Okay, thank you.
Just sort of taking a little bit away from that then. The environmental officers seem to prefer an acoustic fence. Was that a recommendation of the acoustic report as well, or was that not mentioned in the acoustic report? Because that's not conditioned or anything, is it?
Simon,
No.
would you like this one? Yeah.
Yeah, so I'll answer that. Yeah. I mean that is a. I mean, if you wanted a really good noise climate, the acoustic fence. Yeah, and there's an option that members have if you want an acoustic fence. We can put a condition on to say details of the acoustic fence to be submitted and approved.
Okay.
But our view is, and the recommendation reflects that, and it's supported by the applicant, that whilst the independent noise assessment recommended an acoustic fence, and the environmental health officers are recommending an acoustic fence. The acoustic fence itself isn't necessary to make the noise climate above noise standards, the recognised standards. It would be a benefit to the noise climate, but if you weigh the balance, you'd have to put an acoustic fence either side of the hedgerow, and in our view, that's going to sort of harm the character of the area. I think that neat hedgerow on either side of the access drive is quite an important feature of that locality.
Okay, thank you. Councillor Hunter, do you have a question for Officer?
Thank you, Chairman. Yes, it was referenced the number 92 and the amendments that have got to be made to that building to actually accommodate the new access. I wonder if you could expand on that a bit, Mr. Ellis.
Simon, would you like to respond to that? So it did look, on the photograph, it did look very narrow from the gate, the photograph with the gates that you showed us next to number 92 for the new access.
Oh, sorry, just to confirm, the requirement to just alter the area around the dwelling has already been approved. That's part of the extent permission. So it's not part of this application. It's just something that they would do as the next sequence to enable the access to come in. So it's not part of the proposal. The description of development does not include alterations to the existing building. I was just showing you where you would get the access into the development between those two gates.
Sorry, I'm a bit confused about that. So you're saying that, so I know they're using the same access to the two houses, but what is it with the gates then? You're saying that has permission already been granted with the swimming pool for an access through there? Is that what you're saying?
No, the gates, the wooden gates is where the access would come through. So you'd have to take down the gate to bring in the access and then alter that area around the dwelling, but the actual dwelling itself doesn't get changed. So it's the photograph when you saw it, it was the one where the two wooden gates were. So that's where the access comes through.
Okay. Does that answer your question, Councillor Hunter?
Actually, no, Chairman. The point I was trying to make was that how it was going to affect number 92 to accommodate the new dwelling as far as the access was concerned. Because it says it's about removal of existing canopy and post, as well as removal of ground floor side-facing windows as far as breaking up is concerned. That's where I wanted Mr. Ellis to expand.
Can I invite you to respond to that, Simon?
Yeah, that's set out in 4.22. So those works are not part of the planning application that you're looking at. Those works are works that would be needed to facilitate the development, but it's on the same plot, so it's on the same development site. So it's effectively, but my understanding is that those works already had a permission before. So it's just facilitating the new part of the development.
Okay.
Through you, Chairman?
Yes, Hunter, yeah.
Sorry to be persistent on this particular item, because obviously the previous application was refused under D3 on the emerging local plan. And obviously that was to do with the noise, etc. And I assume what's happening here is that the idea of doing this actually negates that actual refusal.
So I didn't quite understand that question, Chair. Can you just repeat it?
Councillor Hunter, would you like to repeat that?
Yes, surely, Chairman. The previous refusal, which was very similar, the inspector refused under our emerging local plan D3. In other words, the noise assessment actually, you're saying now negates it, and that's been made possible by making the amendments on the access and actually breaking up the windows. I just wanted some sort of confirmation on that fact.
Can I ask you to respond?
I think I understand now. No, the reference to policy D3 in the emerging local plan is the refusal of planning permission, not the appeal decision. That was the refusal of planning permission for the additional dwelling in 2019. And the refusal of planning permission was about the noise relationship to the bungalows on either side of the access drive, not number 92 itself. Does that make sense?
Okay, does that answer your question, Councillor Hunter?
Yes, thank you, Chairman.
Thank you. Are there any further questions for our officer? Okay, so there are no further questions. So I'd like to invite Philip Holland to speak in objection. You have 5. Thank you. Welcome to our meeting. You have 5 minutes, and you'll get a warning after 4.5, and then I'll stop you at 5.
Okay, thank you. I had 2 questions, but the first question has been covered adequately in the discussions that we've just heard about the planning document and what regulations have changed. I'd like to concentrate on the second question, which is about the noise survey. This was conducted between Thursday, the 14th of November and Tuesday, 19th of November last year. And an interesting point was we were not aware in the house that a listening device had been placed on our boundary near the bedrooms. That said, I checked my records, and in fact, I'd hired a compactor on Monday, the 19th of November, which was used extensively in the morning in the front garden on the lawn. It is possible to see the trace on the noise survey. And I was required to wear ear defenders while using that compactor. The more interesting part to me was the fact that the noise levels of traffic, assuming it was traffic, that occurred at other times during the week were very similar to that of the compactor period. And I'm asking for clarification of whether the decibels recorded were actually precise and accurate. In other words, were they calibrated beforehand? So given that we're getting similar noise readings for traffic at the monitor point as my compactor had recorded on the device, how accurate is this noise survey? And if so, how much weight will the facade noise exposure assessment be given if this is taken into account?
I will invite the officer to respond to any issues raised by speakers at the end. So if you want to carry on any other points you have to make.
Other than the noise comparison that's in the document, both for this application and previous applications, there was a comparison with the similar development between 50 and 54 Green Drift, which the inspector pointed out that whereas between 50 and 54, the buildings were much further away from the shared drive than was the case with 94.
Okay.
And
is there anything else you'd like to say? Is that all?
No, that is the key change. I'd made my feelings more than plain in all these applications about the noise level, but the noise survey I think needs to be clarified as to whether it's been calibrated correctly.
Okay, thank you very much. So I'll ask our officer to respond to that at the end. Okay, thank you. So are there any questions? Do members have any questions of our speaker? No. Okay. In which case I shall invite our second speaker, Councillor Stanier, as member advocate, to speak. You have 5 minutes and you'll get a 4.5-minute warning.
Hello, thank you. So this is a case with a long history, as you've heard. It was first submitted in 2014, rejected by us, then rejected by the inspector at appeal, resubmitted in 2019, and then rejected and resubmitted this year, with little significant change in between the submitted proposals. In 2015, the reasons for rejection for the application for 3 houses were 4 fourfold, as Simon mentioned, and I'll read some of the other reasons because I think they're also pertinent here. So the committee said that the proposal involves an undesirable subdivision of the existing curtilage of number 92 Green Drift, creating an unacceptable form of backland development. They said it fails to have adequate regard to the character and context of the surrounding area and detracts from the general character and appearance of this particular part of Royston. If implemented and repeated, such development would further erode the essential character of the area, contrary to relevant parts of the local plan and also to the MPPF. Furthermore, it said that it would materially impact upon the character and pattern of the landscape features and private open spaces in this area, harming the visual amenity of the area, also contrary to the MPPF and part of the local plan at the time. Point 3, they said it results in a significant increase in the use of the single access driveway, giving rise to a loss of residential amenity to the occupiers of the adjoining dwellings, and give rise to a more dominant layout, which would adversely impact upon the amenities that adjacent residents currently enjoy. There were 4 reasons. That's the 4th one I think has been thoroughly addressed, but these 3 reasons I believe still stand in the current proposal. In 2015, the reasons for rejection by the inspector were several. Firstly, the inspector said that the effect of the development on the character and appearance of the Green Drift area of Royston was a reason for rejection. The increase in supplies of a single household and would represent a relatively small improvement in the supply against a 50% increase in traffic passing. Concluded that the adverse impacts significantly and demonstrably outweigh the benefits. These reasons again still apply in the new application. 2019, there was an application for this additional house. The rejection by the committee stated that the proposed development would cause material harm to the living conditions of neighbouring properties by reason of noise disturbance. It's unclear why this rejection didn't state the previous reasons which had been made, because they still stood in that application. So while I see that the applicant has clearly tried to take this single objection into account by providing the noise assessment, I don't believe that efforts made are sufficient to outweigh the harms to environment and neighbours and the further changed character, and in this area, nearly unprecedented subdivision of the open space on this area opposite Fairfield Heath, which is a triple SI. Royston Town Council have objected to every iteration of this development as being an overdevelopment and not in keeping with the area, and neighbours on both roads have also consistently objected with reasons around privacy, noise and access. I want to bring your attention to another relevant, I feel, precedent, an application 19/00667 FP, which was also rejected at appeal, to construct a similar access and single dwelling off Green Drift. And it was rejected at appeal by the inspector due to the effect of the proposed dwelling on the character and appearance of the area, creating a visually discordant form of development which would reduce the openness of the land. I believe that under current guidelines, the access to these houses and the subdivision of the land in this way would not have been permitted at all in the first place, and thus the current application should be considered with this in mind. As with the other appeals referred to, though the proposal would provide one further house to contribute to the overall 5-year supply, the development is not in the local plan, and it contributes a very small advantage in this respect of any one house, versus a lot of disruption and reduction in living conditions and change to the area, as well as potentially creating a precedent for such subdivision to proceed nearby and change the character of this area. Although the previous rejection refers only to the noise levels, I believe that as the other reasons for rejection still stand, these should be taken into account. In the case that a rejection now were to come to appeal, an inspector would be required to look at the case from scratch, incorporating all grounds to reject, and there are numerous grounds for rejection that still stand unaddressed. I'd like to thank Mr. Sander Coco for his work on this case and his patience in taking me through the facts, and the members of the committee for your consideration tonight. Thank you.
Sorry, I was muted. Thank you. Do members have any questions for Councillor Stanier? Councillor Nguala.
Thank you, Carol. I just wanted to ask if you could clarify for me, and maybe I've missed it, but the access does seem to be the thing that's in question here, how noisy it will be and how much it takes off of number 92 Green Drift. Who lives at number 92? Is it the applicant? And why?
I believe that's the case. I don't think it is just a question of access, though. I do think that is what's being looked at and focused on here, but I think there are other reasons as well, as I've stated, about the subdivision of the land. Yeah.
No, I understand. To me, it looks like access would be problematic in that they're almost going over 92's doorstep to get into access to the property. That's just my opinion.
Okay, thank you. I've got Councillor Levitt.
Thank you, Chairman. Good evening, Carol. You referred there to significant increase in vehicles accessing the property when in your talk there. Was that that wasn't referring to the single dwelling access, was it? It was referring to the 2015 for multiple dwellings. Am I correct in that one?
It was at the 2015 one, yes.
Yeah, that issue wasn't raised with the other one. Okay, thanks.
However, that came subsequent to the one that had already been granted. So I would imagine that the inspector would be aware that the permission for the two houses had already been granted when they looked at this.
Okay, are there any further questions for Councillor Stanier? No, thank you very much then. We have one more speaker. So can I invite David Farrell to speak in support of the application?
Start my video.
You have 5 minutes and you'll be warned at 4.5.
Thank you very much. Madam Chair, member of the committee, promise not to go on too long on this one. Just like to give a bit of background because that's key to this. It's a bit of potential misunderstanding of what's actually happened in history of this. In 2015, there was an application submitted for 3 4-bedroom houses. This was an application was refused and subsequently dismissed at appeal. It's important to realise that this decision there was based upon 3 key points really. Proximity to the habitable rooms was the key one, which was the reason that the inspector decided to refuse the application because it risked undue adverse impact to the existing dwelling owners there, number 94, sorry. However, in that appeal, I'd ask you to have a look at the, in contrary to Councillor Stainer's recollection of how that application or the appeal was actually stated, the inspector does state that the 3rd dwelling on the site would make better use of the land and that a 2-storey 4-bedroom dwelling with detached double garage would not harm the character of the area or harm the neighbouring amenity. And that's stated in paragraph 14 of the appeal. It's important to understand that both the refused application and the dismissed appeal did not have a noise report to assess the actual impact. As such, it was a decision which the inspector clearly erred on the side of caution. However, the application and the appeal does confirm that the larger 4-bed detached building that was proposed at the time was acceptable in terms of its mass and bulk and overlooking, etc. And the sole reason being dismissed was the potential harm for the neighbouring amenity and due to the increased traffic along Green Drift. This was a 4-bedroom house, not a 2-bedroom chalet. In 18, there's an application for an approval for the indoor swimming pool building. The indoor swimming pool is the same size and more or less the same shape, juxtaposition as the current application as it is today. The buildings have been the same scale, mass and bulk in this location is acceptable. This decision aligns itself with the appeal inspector's comments that it confirms that a building of this size, location and position does not harm the character of the area or have detriment to the neighbouring property. In 19, an application, the most recent application, was refused. This is identical to the one that's before you today, and save for the inclusion of the acoustic report. The application was refused. While it's considered the property itself was acceptable as per the 2018 pool consent, there was a remained concern that even though there were less vehicular movements adjacent to the existing windows of 94 Green Drift than that of the 4-bedroom appeal, there was still potential harm. In planning case law, all previous applications remain material considerations for subsequent similar applications. This is to ensure that it's a consistent decision-making process and that the decisions being taken today remain lawful. As such, given the planning history to date, there remains only one outstanding reason for refusal, which is the impact upon the impact of the additional traffic generated by the proposed 2-bedroom chalet on the habitable rooms of the existing house adjacent to Green Drift. The acoustic report submitted with this application, there remains the concern that addresses this remaining concern, The survey was carried out before the lockdown period. As such, noise levels were assessed when traffic levels were subsequently much higher than they are today and before the COVID situation. The acoustic report confirms that the noise created by the additional traffic of the proposed development is well within the acceptable noise level required by British and international standards. Further to this, the Council's own environmental officer has subsequently confirmed that he agrees with the methods and conclusions in the report, and there's no material harm caused by the proposal. Given the site's history of the approvals and refusals, appeals, it is now a credible fallback position in terms of the building and a clear history of consecutive intrinsically linked decisions. The application brings together the last piece of evidence required to professionally and adequately assess the impact of vehicular movements on the neighbouring property's habitable rooms and confirms that the proposal is acceptable. Just going on to the noise report.
Minutes, Chair. So you've got 30 seconds left.
Thank you. Just very quickly on the noise report, the opening paragraphs do state that the noise listening devices are not listening to voices, they're actually listening to noise, they're sound recorders, and they're set on the boundary and they are calibrated. I therefore respect the committee consider all the history and evidence before them and hopefully approve this application. Thank you very much.
Thank you. Do members have any questions? Yes, I've got Councillor Allen.
Good evening. I'd just like to ask about any possible tree removals that have been mentioned. Is there any likelihood of any major removal of trees?
Other than the one that's in the middle of the site that's shown on the site plan, that is it. It's a pine tree, which I believe was already consented to be removed.
Okay, thank you.
Thank you very much.
Are there any further questions for our speaker?
Could I clarify the 92 Green Drift amendments to the committee? I'm happy not to, but if you would clarify them, I'm happy to.
Normally we take questions.
I know.
That's the normal procedure. So it might come out later. Maybe our officer might have some questions. So I'm going to now invite our officer to respond to any of the issues that have been raised by speakers. Simon, would you like to respond to anything?
Chair, I understand procedure, but it may help if the applicant's representative could clarify the alterations to 92 Green Drift.
Okay.
I don't think I get a brilliant answer to that question.
You can't answer that. Okay, I will invite David to clarify that then.
Thank you very much. Thanks, Simon. The reality is that it's a blocked up window. That side isn't the front of the house. It's the fence. It's not going through the gates. It's not a narrow access there. There is the whole width of that section gets removed. The garage and parking area comes in through that area. And whilst it can fit between the, you saw a photo earlier of a brick pier on the side. It's a cosmetic part of the overhang of the building, and as a utility room window it's a part of the family room side window that sits on that side, which the client's going to block up. He's got the window, the main window faces forward. This is just an additional window, and because it would then change that aspect, I considered it be more appropriate to take a living room space away from that parking area, so there wasn't any disturbance there.
Okay, thank you for that.
Okay.
Simon, do you have any further clarification you want to bring or response to the speakers?
Oh, thank you, Chair. I think what would have been a good idea actually if we'd appended the appeal decision from 2015 to the committee report, because there's been quite a lot of discussion about that, and I think it's just frozen on my screen as well. Right. So because it's important to realise why it sort of got chipped away. You started in 2014 with 4 reasons for refusal, and then there was 2015 there's 4 reasons for refusal, and then the inspector did dismiss that appeal. But I think it's really important to work out what the inspector's view was, and the inspector said there are 2 issues in their mind. It's the effect of the of the development and character appearance of the area, and its effect of the development and living conditions of adjoining residents. So he put two issues in there. And then on the character appearance of the area, he looked at Save Policy 21 of the North Arts local plan, which is the one that deals with landscape and open space pattern. And this area is low density. This residential area is low density, and it's within the Policy 21. So quite often it's difficult to get planning permission for these infill sites because of that policy. So the inspector said, whilst the original dwellings had been demolished at the time of the site inspection, it appears from the location plan that it was largely central on the driveway between numbers 90 and 94. So that's before the two houses were built, and hence would likely have been visible from the road as from the backland development. The two dwelling scheme would be less visible due to the dwellings being placed more to either side. However, the driveway would limit the view of the development on the side due to the cut-off in that the view either side of the direct line along the driveway and the intervening vegetation in adjoining gardens and dwellings on those plots. The single additional dwelling over that found acceptable would not have such an effect on the character or appearance of the area to cause harm in terms of Policy 21. So the inspectors whilst inspectors don't actually write reasons for refusal, you've got to read the whole thing and work out what their conclusion was. So what he effectively said is, he didn't really have a problem with the three dwelling scheme in terms of the character and appearance of the area. He then goes on to living conditions, and this is where he got concerned because as the previous speaker said, there wasn't a noise assessment at the time. So the inspector had no evidence to judge the living conditions arrangement between the access to the site and the neighbouring properties. So he then said, paragraph 13, in conclusion on this issue, there is sufficient risk of the additional dwelling now proposed causing harm to the living conditions of adjoining occupiers by reason of noise disturbance to conclude that the development would not reach the standard of design and layout sought in Policy 57. So he concludes that that's really the main issue that he was concerned about. So he was effectively saying, I don't have a problem in terms of design and layout of three dwellings on this site. I'm just worried about the noise impact. So then a planning application for the one dwelling was submitted again without a noise assessment. And that was refused because of that. In line with the inspector's conclusions in 2015, the officers felt, the council decided, well, we still don't know the noise impact. There is now a new proposal here in front of you with a noise assessment, been assessed by the environmental health officers at North Arts District Council. And that's why the report is written in the way it is. It's a sequence of events that has narrowed down to this noise issue, and we now have noise evidence that's been supported by our own environmental health officers. In terms of the calibration, the point that the speaker was making about the calibration of the noise equipment, I'm afraid I'm not really qualified to answer that question, although the applicant did say something about that. The representative, I'm afraid my screen is just frozen again. I did have a quick look at the noise assessment, and it does say in general, and I mean, I can only give general advice because I'm not a noise expert, but there is already two houses using that access. There's an additional house with some additional traffic going down that access, really going to cause harm to the neighbouring properties on either side of the access drive. That's the key point. And with that noise assessment that's been submitted and our own environmental health officers agreeing with that, apart from the issue about the acoustic fence, which I mentioned earlier, and there's reasons in the report why we don't think that's necessary. It's not necessary to reach the standard. And if you did put an acoustic fence down there, it would look very strange somewhere next to the hedgerow. So that's why we are where we are. And I think it does mean that you are effectively limited to the issues that need to be considered. It has really been narrowed down to this noise issue, notwithstanding the fact that back in 2015, there were 3 or 4 issues thrown at the refusal reason, but those were effectively sieved out by the inspector. So that's my advice, Chair, and I'll take any further questions if there are any.
Okay, thank you, Simon. Are there any further questions for our officer? No. So let's move to debate then. Who would like to speak? Councillor Levitt.
Thank you. I'll start off then. The previous application for the single dwelling, as has been said, is identical to this application. And the only reason for refusal on that was because of the noise levels caused by the vehicle access and everything. While we've been talking, I've gone through that noise level report again as well. And yes, it was calibrated. Yes, it did clear everything. And it gives a typical level of round about 40 decibels, something like that as an average, and it'll increase by 1. 50 decibels is rainfall. So it's quieter than the predicted noise level is actually quieter than rainfall. It's one extra dwelling. Movements are going to be minimal. I think the noise assessment report adequately covers the previous objection. There is a suggestion about an acoustic fence in there, but it makes a bit of difference. But even without that, the noise levels are way below what the normally acceptable ones are. And I say they're well below 50 rainfall noises. I can't see any sustainable reason to refuse this whatsoever based on current policy and that report there. We didn't refuse it before on the impact on the environment. We didn't refuse it before on extra dwellings in the appearance of the area, anything. We didn't mention anything else in that refusal. I can't see how we can refuse it, so I'm going to move we approve.
Okay, I've got Councillor Hunter waiting to speak.
Thank you, Chairman. Yeah, this is, I have concerns over this particular one because it reminds me very much of infill development, which we fought against for a number of years. But looking at this application and 437 and the inspector kicking the other 3 reasons into touch on the previous application, as far as character and appearance is concerned, and now we have a noise assessment, I cannot honestly hang my hat on any reasonable reason to actually refuse. And even highways have issued no objections, which is another reason for us not to actually think that we are able not to grant. So with somewhat reserved feelings on this particular application, I'll second Councillor Levitt's recommendation to grant.
Thank you. I have Councillor Ngawala waiting to speak.
Thank you. I was just going to say that I would like to second it as well, is that even though it looks like this property development is being shoehorned in, squeezed in, and it's going to have some disturbance, it doesn't look as if the disturbance is significant noise disturbance. So I would recommend that we accept the officer's recommendation.
Thank you. Do I have any other people? I've got Councillor Tyson.
Yeah, it's an interesting debate. I was just wondering if there was any feasibility of installing electric vehicle charging posts at the 2 parking bays that were proposed on the site.
Can I ask?
Might encourage people to use a quieter mode of vehicle.
So are you proposing that as a condition?
I was bringing it up for discussion, but if that's appropriate to propose it as a condition, I should do so, yes.
Condition
can I ask the officer then, could we have a condition?
Yeah, I think Councillor Hunter's just answered that. Look at page 61, condition 10. We try and impose that condition on every development of housing. So yeah, it is already covered in there.
It's already covered under condition 10. Okay, so that one's already covered. Anybody else like to speak? Any other members wanting to speak? No. Okay, so we've got Councillor Levitt has moved the recommendation. Councillor Hunter has seconded it. So I think we will now move to the vote. So Matthew, can you take us to the vote, please?
Yeah, sure. Thank you, Chair. So members, if you use the green tick to support the recommendation to grant and no red cross to go against that. Just waiting on one more.
Are you just waiting for me?
Just yourself, Chair, yeah. I've got that. Okay, so that's carried to grant.
Okay, thank you very much. So we'll move on to planning appeals. So I'm going to invite Simon Ellis to present the appeals.
Thank you, Chair. No further updates on appeals. I do have an announcement on the training. Would you like me to make that?
Yes, please.
Yeah, sure. Members aware of the peer review, talked about independent training for planning committee members and indeed all members of the council, notwithstanding Tony Hunter's suggestion that Richard Tiffin's report should be used for training purposes. I agree, it was a very good report, and we will continue to do locally specific training as well as the training that's going to be organised. But I'd just like to mention that I've been in conversation with the Planning Advisory Service, and they're a service that help local authorities with planning problems, and they're very helpful professionals, and they've got a really good understanding of all the wider planning issues. And the Planning Advisory Service are going to be running the training for members. And I've had a good conversation with them. I've talked about the issues that often come up in our planning committees, the sort of context that we've got, the rural area, the green belt, the villages, the pressure for growth, and they're aware of that. And they can offer training on Zoom, so which is the technology that you're comfortable with. And we've got dates provisionally in early September and then early October. And there could be up to 4 sessions that you can take part in, and they think it's going to last 2 hours, and they're going to cover all of those issues. And then they're also going to do, Chair, for you, they're going to do some specific, more in-depth training for Chair and Vice Chair. And that will be coming out soon. The material, I've not received the material yet. I've got to run that past the exec members because they might want to input. But it's all looking good. Interactive training coming up in September time and October time. And then what we'll also do is myself and Nigel Smith will do a session towards the end of the year, December or maybe January 2021, on the local plan. So reflect on all the training that you've done in the Planning Advisory Service, and then we'll bring it locally. And they can then probably come along next year as well. So I think that's a tick done for the peer review. And I think that will help members in the future. Thanks.
Thank you. And can I encourage as many of you as possible to attend that training? It will be done in sessions of 2 hours. It will be done on Zoom. It should be fairly accessible. Hopefully it will be offered in a wide range of times. And also to encourage other members who are not members of the planning committee who might represent their residents as ward advocates. It's also really helpful for them to have the training. So can I ask you to encourage everyone to try do their best to attend? And just before we close, I want to invite our planning lawyer, Nuranetta, to update us about the local plan hearings.
Thank you. Through you, Chair. We have had some correspondence from the inspector. This was last week, asking if we wanted to do a fully virtual examination for the main mods that were postponed after because of COVID in March, or a hybrid. We have gone back to him saying that we prefer to go for a fully virtual because we are using Zoom, and that seems to be working quite well for us on our committees at the moment. So we have gone back to him, and he's proposed a couple of dates. He's proposed the week commencing the 14th of September, the 21st of September, and the 28th of September. So it should be in a 3-week session. and they'll be done by hopefully by the just beginning of October. That's the plan, and that's what we've sent back to him. We're waiting to hear him confirm, but those are the dates he gave us, and we're happy with those dates. So hopefully in the next week or so we should get it confirmed, and then we can put in MIS for all members. But just to give you a heads up that is looking like we're going to commence the main modification examinations and hopefully push the local plan a step forward to adoption. Thank you.
I've got David, Councillor Levitt. Did you want to say something?
Yes, please, Chairman. It was going back to Mr. Ellis's comments about the training, actually.
Okay, sorry, I missed it.
Yeah, Simon, does that take into account the resolution of Council last week that all members who wish to participate in the planning process are required to have basic training?
Yeah, the invitation is going to go out to all members of the council, and they can accommodate as many as can attend each session. So yeah, and the PAS are aware of that. So we're going to try and we'll time the meetings for evenings, probably starting at 7 o'clock, not 7:30, but they won't clash with any of the meetings scheduled in the council's calendar. So we'll make sure that there's full availability, and so hopefully that'll be a good session.
Brilliant, thank you for that. Cheers.
Thank you. I've also got Councillor Hunter. Did you have a question?
Thank you, Chairman. Thank you, Mr. Ellis, for actually mentioning me earlier as far as the planning training was concerned. And it's good to hear that it's going out to all members, because that's the way it always was. It always went out to all members of the North Herts were invited to come and learn about planning, and that's the way it should be. But I do emphasise Mr. Tiffin's report, though, because I did enjoy the fact that he actually looked at the policies, looked at his thinking and how it balanced one against the other. And it was very constructive as far as anybody that didn't understand planning or wanted to learn about planning, because all they had to do was look up the documents and actually understand how they all reacted to each other, how he actually came to his conclusion, which I thought was excellent.
Okay, thank you. Councillor Allen.
Just to follow up on Councillor Levitt. So, Simon, when we have the training, if people haven't attended the training, will they still be allowed to represent at planning?
Well, what we'll do is we want to encourage as many people as possible, many members as possible, to attend the sessions, because then they can actually interact with the Planning Advisory Service. But in the extremis, we can run the material separately afterwards. So it's not going to be impossible, if it really does clash, so we'll make sure that everyone who needs to can have that training available for them. But it just would be much more better. I think members would get a lot more out of it if they were actually in the session at the time that it's being delivered, because then you can interact with the speakers. But there will be a process by which we can roll the same training out to everyone else who wasn't able to attend.
Thank you.
Yeah, I believe it will be recorded because it's on Zoom. So, but as a trainer myself, could I really encourage you to get there face to face? Well, I know it's not face to face, but interactively, it makes a massive difference. You can then ask the questions and you do learn more. So I think it's more worthwhile. So if you can make it at all, let's try and make it a priority to get all our members trained in planning.
Just also add that there will be a few dates, so it wouldn't just be the one date. We're going to have, I think, about four dates, so there should be enough dates for all the members to attend.
Yeah, and presumably if we get enough advance notice as well, we can do our best to attend. So I'm sure we all will do our best to attend, won't we? And it's being provided externally, and I'm sure it'll be really worthwhile. So thank you all, and if there are no further questions, I wish you all a good night for what